lecture, we are going to understand the concept of vicarious liability of the state. Now, in the previous lecture, we have already understood what is vicarious liability. Basically, vicarious liability involves liability of one for the acts of another. Now, why do we understand vicarious liability of the state separately is because in the state, there are certain functions which are delegated to the state by law. And those are the functions which only the state can do. In those cases, with those functions which are called the sovereign functions, the concept of tortious liability does not arise. However, we've seen in master-servant relationship, in the partnership, and in principal-agent relationship, for every wrong committed during the course of employment, the master or the partner or the principal are liable. So let's understand the concept of vicarious liability of the state to understand what are the essentials to hold a state vicariously liable for the acts of its employees or servants. Now here by the state we mean the governmental institutionalities, the government as a whole. Let's first understand the position in England. Why the position in England? Because obviously we have the tort law come into India from there. So, at common law, the Crown could not be sued in tort either for the wrong actually authorized by it or committed by the servants in the course of their employment. So, even if you authorize it or not, you will not be held liable if it was in the course of action. Now, this was the common law situation before the law was passed. Moreover, no action could lie against the head of department or other superior officials for the acts of their subordinates, for relationship between them was not of master and servant, but of fellow servants. So no action could also lie in those cases. The position was entirely changed after the passing of the Crown Proceeds Act, and now the Crown is liable for a tort committed by the servants, just like private individuals. So in England now, the law says that you are liable for torts committed by the servant. The state is liable. Now, what is the position in India? Let's understand first what does the Constitution of India say. So, Article 300 of the Constitution of India states that the government of India may sue and be sued by the name of Union of India, and the government of a state may be sued or be sued by the name of the state and may, subject to any provisions which may be made by Act of Parliament or of the legislature of such a state enacted by virtue of power conferred by this constitution, sue or be sued in relation to their respective affairs in the like cases as the Dominion of India and the corresponding provinces or corresponding Indian states might have been sued or been sued if this constitution had been enacted. Iska matlab, this means that the government of India may be sued in the name of Union of India and the government of a state may be sued in the name of that state. So for example, the state of Madhya Pradesh or the state of Uttar Pradesh, like that. Correct? So for their act, they can be sued. If at the commencement of this constitution, any legal proceeding which are pending to the Dominion of India, to which the Dominion of India is a party, the Union of India shall be deemed to be substituted. Any legal proceedings to which a province or an Indian state is a party, the corresponding state shall be deemed to be substituted for the province or the state in those proceedings. So basically, your name will be substituted on the commencement of the Constitution. This means Article 300 provides that the Union of India and state are juristic persons for the purposes of suit or proceedings. So these are juristic persons. Although the Union of India and the state governments can sue and be sued, but the circumstances under which that can be done have not been mentioned. So what is clear is that they can sue and be sued, but under what conditions, how, all that is not prescribed in the Constitution. According to Article 300, the Union of India and the state government can sue or be sued in the like cases as Dominion of India, and the corresponding Indian states might have been sued if the Constitution had not been enacted. This means that the position of suing and being sued is similar to what happened even before the Constitution was made. So, to know whether the state is liable for a particular act or not, we have to find the position of the East India Company prior to 1858. So basically, we have to understand how did this function in the East India Company regime, and like that, we will see whether it is prevalent, and it is prevalent now also. This is all established through case laws. Now, Peninsular and Oriental Steam Navigation Company versus Secretary of State for India. This is the case which established what is the vicarious liability of the state. In this case, the plaintiff's servant was traveling in a horse-driven carriage and was passing by the Kidpore dockyard in Calcutta, which is the government property. Now, plaintiff's servant was passing through a government property. Due to the negligence on the part of the defendant's servant, that is the government servant, a heavy piece of iron which they were carrying for the repair of a steamer fell, and its clang frightened the horses. Now that person was riding on the horses, and nearby a heavy iron piece fell. When that heavy iron piece fell, what happened? The noise frightened the horses. The horses rushed forward against the iron and was injured. The plaintiff filed a suit against the Secretary of State for India in council for the damages which was caused due to the negligence of the servant employed by the government. Now, the plaintiff sued for the damages and he sued the government for it. The court tried to look to the liability of the East India Company. Now, this said, what is the liability in this case? And this is where they drew a distinction between sovereign and non-sovereign function. And what do you say? Sovereign and non-sovereign function? It was held that if the act was done in exercise of sovereign functions, the East India Company would not have been liable. But if the function was non-sovereign, that is, one which could be performed by a private individual without any delegation of power by the government, the company would be liable. Which company? The East India Company. So sovereign functions are those functions which can only be and only be done by the state. Any function which can also be done by a private individual does not become a sovereign function. For example, maintenance of law and order and police, military, all these are sovereign functions, can only be done by the state. But transportation for police things, that even non-sovereign act persons can do. Privatized things can also be done. Privatization is done. Cleaning of governmental offices, anybody can do. In fact, today they are always outsourced. So those are not sovereign functions. They are non-sovereign functions. Maintenance of dockyards was considered to be non-sovereign function, and as such the government was held liable. Why? Is it only the state which can maintain dockyards? No, anybody can do it, and hence it is not sovereign. Okay, that's why the government was held liable. So here we understand, for vicarious liability of the state, it is important that it is a sovereign function. Sovereign means a function which only the state can do, nobody else can do. If it is a non-sovereign function, something that a private person can also do, in those cases, you can hold the government liable. In sovereign functions, you cannot hold the government liable vicariously. In non-sovereign functions, you can hold the government liable. Now, according to Justice Peacock, the East India Company were a company to whom sovereign power was delegated and who traded on their own account and for their own benefit. Right? So they were delegated sovereign powers to trade on their account and for their own purpose, and were engaged in transactions partly for the purposes of government and partly for their own account, which can, without any delegation of sovereign rights, might be carried on by private individuals. Obviously, East India Company was buying and selling things initially. Now that buying and selling of things can be done by any private individuals, and that is done for their private purposes. There is a clear and great distinction between acts done in exercise of what are usually termed as sovereign powers and acts done in the conduct of undertakings which might be carried on by private individuals without having such powers delegated to them. So there is a clear distinction between sovereign and non-sovereign function. where the act is done or contract is entered into in the exercise of powers usually called sovereign powers, by which we mean powers which cannot be lawfully exercised except by sovereign or private individual delegated by a sovereign to exercise them, no action will lie. So basically, any power which only the sovereign can do or a private person can do after authorization or delegation by the sovereign, only in those cases action will not lie. Now, earlier, there were many acts which only the state could do. There were many restrictions. But now we are open an economy, and there are a lot of things which the private individuals can do, and very limited things which are restricted for the government. The main of them being army work and law and order. Otherwise, everything else can be delegated. Now, the Secretary of State for India in Council versus Hari Bhanji is where the position was explained. The act of the state of which the municipal courts of British India are barred from taking cognizance. So this means for which actions will not lie are acts done in the exercise of sovereign power which do not profess to be justified by municipal law. So acts exercise of sovereign powers cannot be questioned in the court. Where an act complained of is professedly done under sanction of municipal law and then the exercise of power conferred by that law, the fact that it is done by sovereign power is not an act which could possibly be done by private individuals does not oust the jurisdiction of civil court. Now, it says that merely because a power is given by the municipal state does not oust the jurisdiction of the court, because it is not an act which could not have been done by the private individuals. If an act which is done something which can be done by private individuals also, then the state is also liable. Now, Vidyavati versus Lokumal. This is another case where the Peninsular case was questioned and the liability of state was in question. Now, the plaintiff's husband died after being knocked down by a government jeep car which was driven rashly and negligently by an employee of the state of Rajasthan. At the time of the accident, the car was being taken from the workshop to the collector's bungalow for collector use. In an action against the state of Rajasthan, the state was held liable. Yes, correct. That collector has a car authorized by the state. But that car is not something which only the state can run. You can take a private car also. The Rajasthan High Court did not find any reason for treating state differently from an ordinary employer and held that the state of Rajasthan was liable for the wrong of the driver. According to Justice Dave, the state is no longer a mere police state, and this country has been made vast progress since the decision of the Peninsular case was made. Ours is now a welfare state, and it is in the process of becoming a full-fledged socialistic state. Every day it is engaging itself in numerous activities in which any ordinary person or group of persons can engage himself or themselves. Under the circumstances, there is all the more reason that it should not be treated differently from ordinary employers when it is engaging in activities which any private person can engage himself. Here also the distinction was made between sovereign and non-sovereign activities. Any private individual can also do that work, is a non-sovereign activity. Now, on appeal, the Supreme Court confirmed the decision of the Rajasthan High Court and endorsed the view expressed by it. In the case of State of Rajasthan versus Vidyavati, the court made the observations by the Supreme Court, which are as follows. In this connection, it has been remembered that under the Constitution, we have established a welfare states whose functions are not confined only to maintaining law and order, but also engaging in all activities, including industry, public transport, trade trading, to name only a few of them. Insofar as the state activities which have wide ramifications involving not only the use of sovereign power, but also its power as employer in so many public sectors, it is too much to claim that the state should be immune from the consequences of tortious acts of its employees committed in the course of their employment as such, meaning thereby that only if there are some functions which are done which are restricted to the state, like the law and order. Other than that, we are a welfare state. We do so many activities. We are engaged in welfare of the state. So, for all those activities which even private persons can do, you cannot claim immunity of the state. So, the defense of acts of the state will not apply in case of vicarious liabilities for acts which are not sovereign acts. Vicarious liability of state in India. In spite of the decision of Vidyavati, the position is very uncertain and satisfactory. Not very certain. Why not very certain and satisfactory? Because different courts take up different stands. Why different stands? Sometimes there is no clear line distinction between sovereign and non-sovereign function. So this becomes a problem. For example, in COVID, for a long period of time, only government institutes had the power to treat. Government was regulating it. Slowly, it got privatized. Hence, that public-private divide becomes a little difficult. The Supreme Court, in the case of Kasturi Lal versus State, has again stated that if the act of the servant was one which could be considered to be in delegation of sovereign power, the state would be exempt from liability, otherwise not. Now, there are a few positions which have emerged from various decisions of the court, because in sovereign function and sovereign liability and immunity, non-immunity is something that the state has only created out of decisions. So this has come up from the judicial decisions. The liability of the government, that is the union and the states, is the same as what was that of the East India Company. Now, what was that? The government is not liable for the torts committed by the servants in the exercise of sovereign power. The government is liable for the torts which have been committed in the exercise of non-sovereign powers. So in cases of sovereign power, no liability. You exercise of sovereign power, no liability, even if tort is committed. In the exercise of non-sovereign power, liability is there, even if a tort is committed. No, sovereign power means power which can be lawfully exercised only by a sovereign or by a person to whom such power have been delegated. So only a sovereign can exercise that power, or that power can be exercised by an order of the sovereign. There are no well-defined tests to know what are sovereigns. Functions like maintenance of defense forces, various departments of the government for maintenance of law and order, and proper administration of the country, and the machinery for administration of justice, that's the courts, can be included in sovereign functions. Functions relating to trade, business, commerce, welfare activities are amongst non-sovereign functions. So basically, certain categories are sovereign, certain categories are not. A broad understanding is, broadly speaking, such functions in which private individuals can engage are not sovereign functions. The test right now, basic, is if private individuals can also do it, it will not be a sovereign function. Now, what happens in case of negligence of military servants? Now, although maintenance of the army is a sovereign function, but this does not necessarily mean that the state will be immune from liability of any tortious act committed by army personnel. Here also, you will have to draw a distinction between acts which could be done by the government in the exercise of sovereign power and acts which could have been equally done by private individuals. And there is no clear rule for distinction between sovereign and non-sovereign functions. Now, what happens when torts committed by the servants of the state in exercise of obligation imposed by the law and in exercise of sovereign function. Now, a tort is committed by a servant of the state while imposing the law or exercising sovereign function. Now, torts committed while performing duty in discharge of obligation imposed by law has been considered to be a defense in India. Remember, general defenses we've understood. Acts by the statutory acts are a defense. The exemption of the state from liability to pay damages for tortious acts of the servant, where a government servant is carrying out or purporting to carry out duty imposed by the law, has been justified on the ground that in such cases, the government servant purports to carry out the duty imposed by the letter of the law and is controlled by the law and not by the government. So any act which is done in the exercise of governmental function, or that is by the law, something prescribed by the law, in that case you are immune. In order to exempt the state from liability, it is further necessary that the statutory function which are being exercised by the government were exercised by way of delegation of the sovereign power of the state. So you are exercising it in the delegation of power, okay, by the state. In case the tortious act committed by the servant was in discharge of non-sovereign function, the state would be liable for the same. So if you do a wrong, which is by delegation of sovereign power, then only you are protected. If it is a non-sovereign function, you are not protected. The Supreme Court in the case of Kasturi Lal versus State of UP has stated, if the tortious act is committed by a public servant and it gives rise to claim for damages, the question to ask is, was the tortious act committed by the public servant in discharge of statutory function which are referable to and ultimately based on the delegation of sovereign power of the state to such public servant? If the action is an affirmative, the action for damage for loss caused by such tortious acts will not lie. So what is the question? Is it a delegation of statutory function or the sovereign power? If yes, no action will lie. On the other hand, if the tortious act has been committed by the servant in discharge of duties assigned to him, not by virtue of delegation of any sovereign power, an action would lie. So if it is not a discharge of sovereign function or delegation of authority under law, an action would lie. The act of the public servant committed by him during the course of his employment is, in this category of case, an act of servant who might have been employed by a private individual for the same purpose. So if the act is not a sovereign act, it is equal to being employed by a private individual. Now, what happens if there is loss of property in case of an act of the state? When the property is in possession of state officials, it is deemed to be bailment of the property, and the state as the bailee has been held bound to either return the property or pay compensation. For example, if the state confiscates your property, the police confiscates, IT department does it, custom department does it, any of the departments does it, till a case is made against you, they are bailees, they are holding it in bailment. Okay. In the case of State of Gujarat versus Memon Mehmet, the custom authority seized 2 trucks, a station wagon and goods belonging to the plaintiff on the ground that the plaintiff had not paid import duties on the said truck, that they were used for smuggling goods, and that some of the goods were smuggled. The custom authorities made false representation to the magistrate, stating these to be unclaimed property, and disposed of the same under orders of the magistrate. Subsequently, the Revenue Tribunal set aside the order of confiscation and directed the return of the vehicles to the plaintiff. The plaintiff claimed back his vehicle, or in the alternate, the value of the same amounting to rupees 30,000. Here, customs and import and everything is the domain of the state. So if you are smuggling or anything, the state or the police can take action against you. But that property is held in bailment till the case is proved against you. It was held by the Supreme Court that after seizure, the position of the government was of bailee. The order of the magistrate obtained on false representation did not affect the right of the owner to demand return of the property. The government had a duty to return the property, and on its failure to do the same, you have the duty to pay compensation. Now, sovereign immunity is subject to fundamental rights. Even if you exercise your sovereign duty, your sovereign power, you should not violate fundamental rights. If there's a violation of fundamental right, the government will be held liable and you will have to pay compensation to the plaintiff. So in case you are exercising your sovereign right to arrest somebody, but if you cause them injury, or if you violate the fundamental rights, right to life, you will be liable to pay compensation. So what is of essence is that in case of vicarious liability of the state, you have to understand that if it is a sovereign function or something which only the state can do, only in those cases you will be immune from tortious liability, but not if you have violated any fundamental right. If there is a function which private individuals can also do, in those cases, you are not immune from vicarious liability. The state is also vicarious liability for the acts of its servants.